Hello everyone, my name is Aarti and you're watching HW News. In a relief for Kerala news channel Media One, the Supreme Court today lifted the ban imposed by the central government last year. On January 31st, 2022, Media One channel was taken off air after MIB decided to not renew the channel's license in the absence of security clearance from the Ministry of Home Affairs. The court passed the judgment in a special leave petition filed by Madhyamam Broadcasting Limited, the company running the channel. It had challenged the Kerala High Court verdict upholding the ban imposed by the Ministry of Information and Broadcasting. The channel's editor, Pramod Raman, and the Kerala Union of Working Journalists had also filed separate petitions challenging the High Court's judgment. Now, the Supreme Court struck down the ban and pulled up the Ministry of Home Affairs for raising national security claims in thin air without facts. The top court said critical views of the channel against the government policies cannot be termed as anti-establishment, as an independent press is necessary for a robust democracy. Apart from this, the bench made some important observations. Let's talk about it in today's video. But before that, if you're watching this video on YouTube, please make sure you subscribe to our channel, like this video and comment below it. If you're watching on Facebook, then please do not forget to follow our channel, follow our page on Facebook and do share this video. A bench comprising Chief Justice of India D.Y. Chandrachud and Justice Hema Kohli were hearing the Media One case. The Ministry of Information and Broadcasting had refused to renew the channel's broadcast license for want of security clearance from the Ministry of Home Affairs, now which in turn had presented a sealed cover report before the Kerala High Court where the issue was first raised to justify its decision. Now, the High Court had said that though the nature and gravity of the issue is not discernible from the file, there are clear indications that the security of the state and public order will be impacted if permission is granted to Media One. Well, let us hear some of the observations that were made by the Supreme Court in this particular case. Number one, sealed cover procedure. The Supreme Court heavily criticized the High Court's approach in upholding the centre's decision solely on the basis of the sealed cover documents submitted by the Ministry of Home Affairs. Here is what the court said. The High Court did not disclose the reasons for the denial of security clearance. There is no explanation of what weighed in the mind of the High Court, leading it to hold that the denial of clearance was justified despite observing that the nature and gravity of the issue is not discernible from the files. The seal cover procedure, followed by a single judge and the division bench, have necessarily rendered the appellant's right to remedies, which has been described as the heart and soul of the Constitution and basic feature of the Constitution, a dry parchment. The appellant's right to reach remedies have been denied through a formalistic order by the High Court. Number two, raising national security. The judgment authored by CJI D.Y. Chandrachud emphatically stated that the state cannot deny the rights of citizens by merely raising the plea of national security. The bench further observed the mere involvement of issues concerning national security would not preclude the state's duty to act fairly. If the state discards its duty to act fairly, then it must be justified before the court and the facts of the case. Firstly, the state must satisfy the court that national security concerns are involved. Number three, national security used to deny citizens' rights. The judgment observed that absolute immunity from disclosure cannot be granted to the reports of investigative agencies such as CBI and the IB. The judgment also specifically commented about the cavalier manner in which the Union of India has raised the claim of national security. The bench said, other than merely claiming that national security is involved, both in the affidavit that was filed before the High Court and in the submissions before us, the Union of India made no attempt to explain how non-disclosure would be in the interest of national security. The Union of India has adopted this approach in spite of reiteration by this court that judicial review would not be excluded in a mere mention of the phrase national security. The state is using national security as a tool to deny citizens remedies that are provided under the law. This is not compatible with the rule of law. Number 4. Duty of the press to speak truth to power. Significantly, the Ministry of Home Affairs had relied on reports of the Channel on Citizenship Amendment Act, National Register of Citizens, and criticism of the judiciary, state, etc., to state that it is an anti-establishment channel. However, the top court said that these are not justifiable grounds to refuse renewal of its broadcast license. An independent press is vital for the robust functioning of a democratic republic. Its role in the democratic society is crucial, for it shines a light on the functioning of the state. The press has a duty to speak truth and present citizens with hard facts, enabling them to make choices that prepare democracy in the right direction. The restrictions on freedom of the press compel citizens to think along the same tangent. A homogenized view on issues that range from socio-economic polity to political ideologies would pose grave dangers to democracy. Number 5. Channel criticizing government cannot be termed anti-establishment. The court further stated the critical views of the channel media, one on policies of the government, cannot be termed anti-establishment. The use of such terminology in itself represents an expectation that the press must support the establishment. The action of the Ministry of Information and Broadcasting by denying your security clearance to a media channel on the basis of the views with the channel is constitutionally entitled to hold produces a chilling effect on free speech and in particularly on press freedom. The bench further stated the alleged link of channel's shareholders to Jamaat-e-Islami Hind is not a legitimate ground to restrict the rights of the channel. In any event, there is no material to show such link, it said. Also, when Jamaat-e-Islami Hind is not a banned organization, it cannot be contended that the links with the organization would affect the sovereignty and integrity of the country, the security of the state, friendly relations with foreign states, or public order. The court allowed the appeals of Madhyamam Broadcasting and other appellants and directed the MIB to renew the license within 4 weeks. On March 15, 2022, the court had passed an interim order allowing the channel to continue its operations pending the final decision, which was made absolute today. Well, that's all for this video. Tell us what are your thoughts on this in the comment box below. For more news and updates, you can log on to www.hwnews.in.